daily list item number 1. Yes.
The counsel for the petitioner is in another court.
You are for?
I'm for the petitioner.
You saying the counsel for the petitioner is in another court, but you are for the petitioner.
Yes.
So you are in that court or here?
Yeah, Your Lordship.
This matter is fixed for
Yeah, part heard matter, Lordship.
part heard.
Yes, Lordship. It's a devotion matter, Lordship. Demotion. So Sheikh is the counsel.
This is with regard to those RTE
Yes, Lordship.
rules and the tribunals.
Mr. Gurung was doing this matter.
Sir,
You are appearing?
Keep it.
Sir, keep you.
End of the board.
End of the point. Yes, answer. Yes.
Item number 3.
Yes, who's okay? You are in this case?
7 and 11.
7 and? Okay, quite a number. Yes, you are for?
I'm for the petitioner, my lord, in this matter.
All the respondents are here.
State respondents missing. Mr. Amit, he informed me that, my lord, he has some difficulty today. He is appearing for majority of the respondent.
Who?
No, no. Mr. Amit, he is appearing for respondent, quite a good number of respondents, my lord. So they have some difficulty. He was telling me in the morning, he was requesting me if this matter can be taken up next week only.
No,
Next week?
it's a 2017 matter.
Next week, my lord, we'll do it. He will be here, my lord, next week. Joshi.
So all the respondents, except for respondent, state respondent, you mean?
No,
Mr. Khan, you are appearing?
I'm for the state, Your Lordship. State has a limited role, Your Lordship.
No, not limited.
No, I'm apologizing.
Full role. Mr. Kharmi is also not there today, my lord, who is handling the matter.
Basically, he is the counsel entrusted with this case, Your Lordship. Anybody, in any case, they are asking for next week.
Today, there's not much matter on the board.
Lordship, absolutely. You should have been taken this.
You could have taken the opportunity to get it over and done with.
What are you asking for next week? Let's see, Lordship. If it's next week, we'll try to finish it.
What is the matter about, Mr.?
It's all about appointment, my lord, appointment of the private respondent. There was an advertisement floated by the state, my lord, for Garo lecturer in government college, my lord. Now our contention before this code is very limited, my lord. In a sense, my lord, that the expert who was taking the interview, my lord, whether she had that qualification. Like for example, my lord, if a football team is supposed to be selected, a cricketer was sent. Whether that is the only ground, my lord, that we are harping on it.
Cricketer can also play football.
In India, my lord, it is possible, but not in.
But the Lordship, the important should be whether it was a football ground or a cricket ground.
There, my lord has to decide, my lord.
Playing cricket is
I
a
recall
football.
the issue now. In fact, I had requested Mr. Kharmi, if I must, to show me the relevant rules. Or was it the counsel for the Public Service Commission?
No, it was Mr. Kharmi who was supposed to inform this honorable court.
The qualification.
Qualification.
That is
Yeah.
very, he's made an interesting case.
member.
Yes, definitely.
Expert
Whether qualification was there or not. And if it is not there as per rules and
If
Qualification would mean the degree or
Exactly.
the experience.
all the expertise, yes.
Because apparently you said she was teaching Garu for a number of years, 20 years or so.
30.
that is the only limbs of my argument, my lord. If I fail on that, my lord, I fall down heavily.
That's what. Very limited issue to be. Why are we dragging on?
Next week. Well, Lordship, playing football and falling down is one thing, but playing cricket and falling down.
Krishna must have been bled dry by now.
Red cap.
Red card.
Mr. K. Khan, AJ has submitted that has sought for accommodation in this matter on behalf of the state respondent on the ground that the General Conducting Council is indisposed for the day. Though no strong objection has been raised by the petitioner, this court would observe that the matter being a very long pending one, it would be incumbent upon the parties to ensure that the same is disposed of as early as possible. Accommodation sought for is granted. However, no further adjournment will be allowed on a date fix. This is matter to 2 weeks.
Item number 4.
May it please your lordship.
Yes.
Lordship, on 17th of this month, we filed an affidavit bringing on the record the license, the copy of the license.
Okay.
And as far as that, in the last order is that the permission for those things. So that is the only the copy that previously was submitted. Only we have that. No such things are there. Only those documents only we are relying on. And this is the fresh license after renewal that we have submitted. Copies have been served to all the parties.
Milord, I have one submission to make, Milord. If your lordship kindly see your lordship's order of 29th April 2024.
Yes.
Your lordship directed the petitioner to place 2 things, Milord. 1, license, and also permission to erect or construct the sawmill therein. Kindly see I had advanced this argument on behalf of all the respondents. However, in course of hearing, this court has made a query on certain point to be clarified by petitioner, particularly with regard to extent of initial license issued to the petitioner to function from industrial estate area, and also with regard to permission to erect or construct the sawmill there. Now, my lord, what has been filed by the petitioner before your lordship by way of additional affidavit is the license only, but there is no document showing permission to erect or construct the sawmill there. My friend can clarify on this aspect because there is no affidavit, no document filed by my friend showing permission to construct or erect sawmill at the relevant place. And the entire case, my lord, is based on compensation for so-called acquisition.
My lordship. Lordship, in 1999, the land was allotted to me. To do what? It was shifted, not just fresh allotment, because earlier it was in some other place. On the direction of the Honorable Supreme Court, I have been allotted the land. So definitely, I was running a sawmill there. So definitely, when the land is allotted to me, definitely I'll do the business, sir.
Yeah, but the initial, you've got the copy of the initial permission given to you in the previous land. There must be, see, if you had the...
Yes, in the affidavit, I filed the affidavit before. The affidavit is there. Like initially, when he is me mean to do, the land I was running there. After the direction of the Supreme Court, that all the unit has been transferred to the industrial estate. So
have you made such amendment in your petition?
No, it came later on when that court is inquired, Your Lordship, in order also since the inception, when this is incepted. So I brought all the records from the inception till the transfer of my unit to the industrial state. So obviously, when my land was transferred to here, so definitely to run what? To run a sawmill, regarding which the license was issued. This license was not issued to graze or do some other business. This is completely a sawmill, is written here. So definitely I am doing that business. And as far as the erection and the building is concerned, it is constructed way back in 2007. 1919 was allotment was there, then all the process going on. So and all these years, my unit was running. I am paying necessary fees to the DIC. There's no objection. All of a sudden saying that I don't have the building, I don't have the permission. If the permission is not granted, how long this unit was running without any permissions, and how the government, how the state.
It was illegally run. It was illegally running.
But
my
they're
lord.
receiving the
It
rent.
was illegally run because
They're receiving the rent.
there is no permission to construct.
Yeah, Mr. Kumar.
The license is
Mr.
there,
Kumar,
but there is no permission.
Just
If my unit
let
is,
Mr. Burwa.
if my
Don't browbeat him.
No prohibiting, my lord. But because his lordship's order has not been complied.
The issues
Because
are
your
clear.
lordship's
If my
order
unit
is
is
very
illegal.
clear.
If he
If
can,
my brain is free that no
there is-
permission is there, I have no nothing to say.
if there is a reasonable explanation, the court would accept it.
So if
My lord, I will answer when my turn comes.
Where is the affidavit you have filed
this fresh one or
with
the
regard to the that aspect?
exception? Yes, Your Lordship. Your Lordship, this affidavit dated 23rd August 2022. That is that addition affidavit to bring on certain documents to ascertain the inception of the unit.
23rd.
23rd August 2022.
This is your this type copy of Annex A.
No. This is that that is a type copy of that blueprint. Another one is ascertain the inception.
Just a moment.
It's the same date affidavit because I fill in the same date.
Yes.
Your Lordship, I like to take the Annexure B, page 6. Yes. Number 2 is the petitioner. Look at the address, Your Lordship. Srimati Bislina Warpasa, Mimintudu. That means my unit was before in Mimintudu. And what is that subject? Proposal for allotment of land at industrial estate, Kritrichi. So, with reference subject mentioned above, I am to inform you that for the allotment of land at industrial estate, you are first required to apply for a provisional registration.
Just a moment. Annexure B.
Annexure B1, page 6, Your Lord.
Oh, B1. Yes.
Number 2 is the petitioner.
Yes.
His address was Mimintudu. That was the university belonged initially. So, the subject was proposal for allotment of land at industrial estate, Kritrichi. So, with reference subject mentioned above, I am to inform you that for allotment of land at industrial estate, you are first required to apply for a provisional registration to the GM DIC Joy, Lordship. Thereafter, Your Lordship, page 7, B2. Again, this letter was written by the General Manager DIC. Provisional registration for proposed SSI unit. I am sending here the provisional registration certificate so and so to say that all instruction issued by this office from time to time should be strictly followed. Your Lordship. Annexure 3, page 8. This is very important.
Yes.
Same. Bislina was a Mimintudu. Subject shifting of sawmill cleared by the HPC, High Power Committee, to notify industrial estate. In view of the CFME having clarified indisputedly through this letter dated so and so, stating that those sawmills cleared by the HPC may be allowed to shift to industrial estate. to establish their machineries at the allotted site, you are hereby directed to shift your machineries and equipment, your lordship. This is very important. Pertaining to the sawmill to the plot allotted to you within 15 days of this letter. This issue as per the direction of the Honorable Supreme Court. So that is from this letter, it has been clearly verified that my unit was running earlier in the Mimintudu. After the direction of the things, it has been shifted. So all the machinery.
So
now
you have done so.
Yes, we have done so. So when I have the machineries, other equipments, what do? I keep it in the open? Definitely. Because it is not the fresh unit to me, fresh allotment. It is in pursuance to the Supreme Court order. So definitely my structure has to become. Now they are saying that you don't have a permission for the structure. If it's so, sir, then in that case, or how long till date you are receiving all the charges and fees from me from an illegal structure? This is what the state contention. This is my only submission. Nothing else. That I have produced that original things, the fresh license, the renewed license, which I have, which is expiring. Though it is expired, they must have applied. It is expired on up to 31st December 2023. Now it's month of May. They must have applied the fresh one. That is page 5, annexure C1.
Yes.
Just I leave it to the wisdom of the court.
Yes, Mr. Kumar, what do you have to say?
Yes, my lord. Lordship, if your lordship will recall the basic bare minimum facts. My friend may be saying too many things, but his writ petition is only for the purpose of seeking compensation. And he is making a prayer in the writ petition that his land has been acquired, therefore the government be directed to pay compensation for acquisition of land. Kindly, so this is his case, my lord, what he is trying to say in the prayer, my lord. Kindly see prayer 70, I may be wrong. Kindly see his prayer, my lord, what is his prayer?
Yes.
Kindly see prayer. What is his prayer? Graciously pleased to admit the petition. Lordship got the
Yes, yes.
call upon to why a writ in the nature of mandamus certiorari not be issued directing the state responding
No, Lordship.
to shift the ST line.
Yes.
What is the prayer? Please tell me.
Lordship, I think so. The sir is reading the previous, not the amended one. I filed the amended.
I have got both amended and the current one.
Amended
Also.
is not respondent. There's only 4 5 is mentioned.
Petition is also there.
Yes, let us look at the amended petition. Yes, CM. Prayer is CM, Mr. Kumar.
The amended petition also should not be issued directing the state respondent to shift the ST line at land of the petitioner industrial estate 33C, a direction to respondent number 4 and 5 to revert the possession of land illegally occupied in the industrial area 33C to the petitioner forthwith. Pass a writ in the nature of directing respondent 4 to pay compensation for lost damages caused to the petitioner. So there are two prayers which are there before the Lord. First, that he is having land at 33C, land or the lease in the industrial plot at 33C, and direction by your lordship to the respondent to shift the line, electricity line over his land. You know, these are the two basic prayers which are there before your lordship. Kindly see who is having the lease, my lord. Lease document is placed before your lordship by the, not by the respondent, my lord, not by the petitioner, but respondent has placed. He has filed a case, but he did not place any lease document. Kindly see page 6 of the counter affidavit filed by respondent, my lord. Respondent number 2 to 3, my lord.
Yes, ma'am.
He files petition, but he does not place the lease deed, my lord.
Respondent 2,
It is
3.
for the petitioner to place all records.
Just
Respondent number, lord,
yes. Page 6.
2 and 3.
Yes,
Yes, page 6 is the lease deed.
Lease deed, yes.
Annexure I.
Yes, yes.
Your Lordship will see the lease deed is dated 17 September 2012. Your Lordship may make a mental note of the date, 17 September 2012. This is the lease deed between Director of Commerce and Industries and my lord, kindly see the lesser.
Okay.
This is the lease, and then the lease deed is period starting 25th April 2007, my lord. Kindly see next page, page 7.
Yes.
For a term of 30 years. And the most important term is paragraph 5, my lord.
Yes.
The lessee shall, within 1 month from the date hereof, submit to the lessor or his authorized agent for his approval the specification, plan and other details of every shed or structure to be constructed on the demised premises, and at the direction of the lessor or his authorized agent, lessee shall amend his said plan and specification and other details. Now 6 million.
Yes.
7. Kindly make note of 6 and 7. 6 requires within 1 month he will submit the plan and everything. 7 kindly. The lessee shall not erect or build or permit to be erect or build on the demised premises any building said. Page 8, clause 7 at the top. You also got it?
Yes.
The lessee shall not erect or build or permit to be erected or built on the demised premises any building, shed or other construction other than those approved by lessor or his authorized agent, not making any subsequent addition or alteration to the existing building and shed at any time except with the written approval of lessor or his authorized agent. So these are the two clauses. First, after signing clause, your lordship has seen, clause 7 requires approval.
I can't hear you.
Now kindly see your lordship's order. I'm sorry, your lordship can hear me now?
Yes, now I can hear you.
Sorry, lordship will see clause 7.
You are referring to clause 7.
7, I refer to clause 7. Clause 6 required permission within 1 month, and 7 required, my lord, that, and 8 kindly see, my lord. 8.
Yes.
In the event of lessee fails to comply with the terms and conditions, here too said lease shall be automatically terminated with right of lessor or his authorized agent for re-entry. So if you violate, there is an automatic deemed termination, my lord. Now kindly see your lordship's order of 29th April.
Yes.
My lord, I showed these clauses to your lordships on last date of hearing.
Yes.
I showed, my lord.
Yes.
I showed these clauses, my lord, these provisions, my lord, on last date of hearing, and then thereafter your lordship has noted in the course of hearing, this court has made a query on certain points to be clarified by petitioner, particularly with regard to extent of initial license issued to the petitioner to function from industrial estate, and also with regard to permission to erect or construct sawmill therein. Now these are the two things, lordship. Barua Praise may be allowed to file additional, to bring document on record. Now kindly what document he has brought before your lordship, kindly see the additional affidavit with me, my lord. He has produced before your lordship at page 5 of the additional affidavit.
Yes.
Renewal of his sawmill license, my lord. From which department? Forest and Environment Department. Renewal of license is one thing, and permission to construct the said structure as per the lease document is the other thing. Everyone who has got the renewal license, my lord, and he is not allowed or to establish or run unauthorized or create unauthorized construction. He will have to take permission from the competent authority, my lord. Admittedly, he has no permission, my lord, and this is the affidavit which was filed by Industry Department, my lord. Kindly see the affidavit in this light. Paragraph 5, my lord, of my affidavit of in which lease deed was appended.
Yes.
Paragraph 5, my lord. Beg to state that Krishna, who is the proprietor of Messrs. Bilstina War Pasa Sawmill, Veneer, had been given on lease of plot for land at measuring 3,000 square meter in Cletrisi Industrial Estate, Cletrisi, West Jaintia Hills, for setting up saw Veneer for 30 years. The lease which I have shown below. As per clause 5, the lease agreement it is required that lessee shall within 1 month from the date hereof to submit the lesser or his authorized agent for his approval a specification, plan and other details of every shed or structure to be constructed on leased premises at the direction of lessor or his authorized agent. Lessee shall amend at his own cost the said plan, specification and other details. Further, undergoing construction of RCC building in the leased property undertaken by petitioner which the ST line passes has not submitted any proposal to the answer for construction of structure in contravention of requirement of clause 5 of the lease dated 17/9/2022. So he has constructed RCC building in contravention of section clause 5 of lease document. Now he is before your petitioner is before your lordship with a prayer to the respondent number 5 and 6 to remove the ST line on a piece of land on which he has constructed the building illegally. Now your lordship is aware, Miller, that writ petition is maintainable only when a person is having any legal or statutory right. First, he has to establish his legal right, my lord. Then your lordship will issue direction to the respondent to amend or to meet the legal requirements. If there is no legal right, no writ is maintainable. First, and for that purpose only, your lordship has directed the respondent to show the permission, my lord. Did you have the permission to run the sawmill or not? Did you have permission to construct the building on the piece of land or not? And he has not placed that document. What is his argument before? I have been running, therefore I am entitled to prayer before your lordship. You may have been running without permission. You may have been running and you may have constructed, because the affidavit of the industry department is very clear that there is no permission and he has failed to produce any permission before your lordship. Despite clear and unequivocal order of your lordship and undertaken by the petitioner. So I was not browbeating him. I was trying to point out the correct facts which he was duty bound to place before your lordship. It was his duty to place all these correct facts. It was not my duty that this was the order and I don't have permission. He should have said this, but he is not honest, my lord, when he is not placing the facts correctly. He may have explanation for not placing it, but that is a different thing. First thing what he was required to do is he should have said, yes, I have got the renewal license, but I don't have permission from the industry department in terms of the lease document. This was my precise argument on last date of hearing. And today also this is my precise argument. So this is now therefore in that light, my lord, I have already submitted two things on last date of hearing. I have almost concluded the argument on last date of hearing that he has no legal right in view of the lease document. Secondly, even under the Electricity Act, there is a provision of the Electricity Act which requires, and regulation has been framed, my lord, that was also placed before your lordship. Kindly see the regulations and law relating to shifting of line, my lord, which is part of page 13. Page 13 of the counter affidavit filed by Electricity, my lord, by respondent number 4 and 5.
Just a moment. Let me just note down.
Because ultimately, my lord, we are in the court of equity, where we honesty, clarity.
Mr. Kumar, you are appearing for MECL or you are appearing for state?
I am appearing for all the parties, my lord, in this case. If your lordship will see your lordship's last order also, it is recorded there that I am appearing for all the parties.
Yes, please. You are referring to
Yes,
electricity
I
regulation?
am referring to the counter affidavit filed by respondent number 4 and 5, my lord. Because his prayer, I have shown the prayer before your lordship. Prayer is direction to respondent number 4 and 5 to shift the ST line
Yes.
on his piece of land, which is his, it is not his piece of land, which I have already shown.
Yes. This is your affidavit dated?
Yeah, your lordship, my affidavit is dated. Affidavit is 13 December 2018, my lord.
13 December. Para?
Your lordship will see the document, lordship will regulation.
Where is it?
Regulation at page 13, annexure 5, my lord.
Extra 5.
Yes, my lord.
Yes.
Erection or regulation 63, my lord.
Yes, yes.
Erection or alteration of building, structure, flood bank and elevation of roads. If at any time subsequent to the erection of an overhead line, whether covered with insulated material or not, any person proposes to erect a new building or structure of flood bank or to raise any road level or to carry out any other type of work, whether permanent or temporary, or to make in or upon any building, structure or flood bank or road or permanent or temporary addition or alteration, he and the contractor whom he implies to carry out the erection, addition, or alteration shall give intimation in writing of his intention to do so to the supplier of honor and to the electrical inspector, and shall furnish therewith a scale drawing showing the proposed building, a structure, flood bank, road, or any addition or alteration, and a scaffolding thereof required during the construction. On receipt of such intimation, supplier or honor shall examine whether the line under reference was laid in accordance with the provisions of these regulations and any other law, whether it is technically feasible, whether it meets the requirement of right of way, whether such person was liable to pay the cost of alteration of the overhead line, and if so, send a notice without undue delay to such person together with an estimate of cost of expenditure likely to be incurred to so alter the overhead line, require him to deposit within 30 days of receipt of this notice with the supplier or owner the amount of estimated cost. If such person disputes the cost of alteration of overhead line estimated by supplier or owner or even responsibility to pay such cost, dispute may be referred to electrical inspector whose decision thereof shall be final. So, my lord, under regulation 63, if somebody wants to shift the line, what he has to do is to approach the authority. The authority will assess the cost. On assessment of the cost, the person concerned will be informed of the cost. If he disputes the cost of the shifting of the line, then the matter will be referred to electrical inspector and his decision will be final. This is the law framed under the Electricity Act. And this law is binding on him and me, both parties, my lord. So therefore, the prayer which he is seeking, my lord, is that direction from your lordship to not to follow Regulation 63, my lord. Regulation 63 is clear, law is very clear, which is binding on him and the parties, my lord. Now, in this regard, my lord, inquiry was constructed, inquiry was carried out, and after carrying out the inquiry, the cost was intimated to him. Cost was intimated to him, my lord. Sometimes I am really aghast to see the petitioner is duty bound to place all these materials before your lordship. Those letters are addressed to him. Those letters are before him, but he suppresses all those documents and come to your lordship and seek direction to the state. My lord, there has to be some standard and probity maintained in the writ petition, my lord. Because if you are having those documents, if you are not placing those documents, then you are not approaching the court with the clean hands. Your lordship, kindly see the correspondences between the parties, my lord. Constructed, we kindly see the government in this regard, my lord. Paragraph 6 of the same counter affidavit, my lord.
Paragraph 6.
Yes, my lord.
Yes.
With regard to statement and averment made in writ petition, paragraph 4 and 5 of the writ petition, deponent denies the same. Deponent states the transmission line of the department has been constructed way back in 2007 after informing all the concerned authority via letter number so-and-so dated 22nd May 2007, including the office of respondent number 2. There was no objection raised at that point of time for construction and erection of ST line through the property of respondent number 2 and unit occupied by petitioner which falls under the industrial unit of respondent number 2. However, on 11th March 2016, after lapse of almost 10 years of the construction of ST line, petitioner while later dated 11th March 2016 requested the office of respondent number 4 to shift the existing line which is passing through the property of the petitioner since he intend to construct a building. Electricity transmission line are basic and essential public utility services and have been services the electric are basic and essential service and have been laid down by the following all prescribed rules, regulations and guidelines and Electricity Supply Act 1948 and Electricity Act 2003. As per the request for safety alteration of any existing transmission line is concerned, Regulation 63(1) of Central Electricity Authority, measures relating to safety and electricity supply regulation 2010 provides that in case of a landowner seeks alteration, shifting of any overhead line, such person is liable to pay the cost of alteration. Thus, mechanism is provided under the statute and rules for redressal of such issue. Respondent 4 on receipt of application has prepared an estimated bill for shifting of line wide letter dated 22/4 informing the petitioner about the cost of shifting the lines through the estimated as provided in 63(1) of the state regulation. Now that I have already placed 63(1), my lord, in the annexure.
Yes.
Now, your lordship will see paragraph 7. The second line of paragraph 7, the deponent states that petitioner instead of making the necessary payment has requested respondent number 2 wide letter number so and so that line so and so has carried out a joint survey of shifting of line, double line. It has been mentioned shifting line is impossible following the illegal construction of building under ST line by the proprietor. So he has constructed illegal building, my lord. He is not denying this fact that he has constructed the illegal. First thing which in my humble submission, my lord, the court should inquire under what authority he has constructed the illegal building, my lord. A person who has constructed the illegal building coming to this court and saying that direct the respondent number 4 and 5 and respondent to shift the line without following the law. First, he has to meet the standard of law that he has not done something a person who has done something not legal, he is not entitled to come and seek perpetuation of his illegality. That is, the illegality is, Milord, that he has not produced the permission of his construction from the respond number 2 and 3, Milord. That is the director commercial. It has been mentioned, and his answer is, I have been running, I have been paying, and therefore it is legal. A thing which is illegal from inception will not become legal merely because you have been paying something, and that is, there is no document what he has been paying. Where is the permission? As per lease document, Milord, which I have shown, that if you violate the terms and conditions of lease, the lease will stand terminated automatically. Even there is no further requirement under the lease document. So if your lordship will see all these facts taken together, what emerges in my humble submission is he is seeking certain directions which are not, in my humble submission, legally tenable, because first you have to establish a case in law that my entitlement, my legal right has been violated. My legal, and therefore the Honorable High Court will come and in rescue of a person whose legal right has been violated by the state authorities, my lord. Now, he has miserably failed to show any of his legal right, my lord, and I will place those annexes also, my lord. Kindly see page 7 of the same affidavit, my lord, the annexer 1.
Yes.
This is the first letter written by Meghalaya State Electricity Board.
Yes.
Then informing the manager DIC literacy that it is going to erect the high tension line over the industrial estate, my lord. Who is the owner of the industrial estate? The industrial, it is the industrial authority. Now there is a letter by, now the reliance is placed by the petitioner on annexer 2 of page 8, my lord. Petitioner is relying on this letter. The letter written by Director of Commerce Industry to Executive Engineer, my lord, and this is by, with reference to cited above, I am to reiterate that 33 kV lines are passing through literacy in general and industrial and so were constructed without prior permission from department. As such, incumbent upon corporation to shift the own cost, question of payment of does not arise. So then this is a dispute which is going on in the industrial department and all. After this letter, my lord, the correspondences has taken place. After correspondences, my lord, kindly see the stand of the industry department, which is there in the second affidavit, my lord. Second affidavit, which is page, the second affidavit filed by industry department, my lord, which is dated, which is filed in the month of 9th July 2019, my lord. This is the affidavit filed by respondent number 2 and 3, my lord.
Okay. One and 2 and 3.
Yes, my lord, and paragraph 12.
Yes. Para 12.
Sorry, my lord, page 12, page 12. Annexer 2.
Yes.
Page 12, annexer 2, my lord. This is the letter addressed by Director of Commerce and Industry Department, rescinding its earlier letter, shifting of 33. If your lordship will see the letter dated 8 July 2019, addressed to the Executive Engineer, Joy Distribution Division, Meghalaya Power Distribution Corporation Limited, shifting of 33 kV, 11 kV lines and industrial estate 3C. On examination of earlier communication issued by letter number dated 29/11/2017 and taking into account that MSEB, now Meghalaya Power Distribution Corporation, has sought cooperation of all concerned, including this department, prior to the construction of 33 11 kV line which pass through Clay-Tracy Strait. Second, construction of 33 kV and 11 is meant for uninterrupted, interrupted supply is wrong, uninterrupted supply of power for larger interest of the public, later dated 29/11/2000 hereby cancelled. The previous letter which I showed, my lord, that has been cancelled. So there are two facts or three things, there are three arguments which I have, my lord. If I sum up my argument, number one, my lord, petitioner has established no legal right for filing the writ petition. His legal right is based on the lease deed, which has certain terms and conditions. One of the condition of the lease deed is that within one month he will submit the drawing for construction of RCC building. The lease deed clause 7 also contains the clause that he will not construct the RCC building without prior permission of the concerned authority. And clause 8 of the lease deed provides that in case he fails to do so, the lease deed will stand cancelled automatically. So this is one part of my submission, my lord. Second part is assuming that he is in occupation of the premise in Clay-Tracy Industrial Estate and he has constructed some building illegally, my lord. And the report says that he has constructed the building illegally without permission and he is not even now the original owner or real owner of the industrial estate is the industry department, which is saying that this S33 kV line is in public interest. Therefore, there should not be shifting of 33 kV line. That is one aspect of the matter from the industry department perspective, my lord. Now, second aspect of the matter is from the electricity and Meghalaya Power Distribution Corporation Limited is, my lord, that assuming that the petitioner was having all legal rights. Even in that case, Regulation 63 will come into play, which requires that he will have to bear the cost. He will have to, the MEPDCL will have right to of way under the Act, because your lordship has seen that all those electricity lines are passing through some private properties only. But that does not, and there are certain requirements. You have to seek permission of the concerned authority. You may be the owner of the land, but the law, because there is a statutory law which provides for ways and means of doing things. So you have no legal right per se to come to the court and ask for direction, which is not in consonance with law. First, you have to show that this is the legal injury which has been caused by action of the state authorities. And legal injury means you have to establish the legal right, which in my humble submission, my lord, petitioner has not failed to produce any document. He should have produced all these correspondences. He has not produced anything. Even your lordship has directed to produce the document. Again, that has also been, the petitioner has failed to produce. So in my humble submission, there is no case whatsoever warranting interference by this honorable court in this matter, my lord. And this is all, that is all I have to submit on the writ petition, my lord.
My lordship. Lordship, page 20 of my amended writ petition, there is a type copy. Page 20. Page 20.
Yes.
So this letter is written to the respondent number 2, that is senior electrical inspector, by the respondent number 4 and 5. I just like to take the operative part. The last fourth line from the starting of sir. Sir, on inspection in your presence on 8 December 2016, it was noticed that another building was also under construction just under KV so and so by the same person. As such, you are requested to look into the matters and take necessary action as provision under section so and so electricity rule. In pursuant to this, Lordship, I'll take you to the page 23 of my amended petition.
Yes.
That is written by the Director of Commerce to the Executive Engineer, MSCL. Subject shifting of so and so interstate state. Sir, kindly refer to the report of the joint survey for shifting of 33 kV Kletrichi so and so and industrial state Kletrichi conducted on so and so jointly by Sri H. Law AE, number 2 Sri Dick India JE, and number 3 P. Toy, General Manager. That is the crack of the case. Here, the P. Toy is the General Manager of the DIC, Juai, and Sri G. Lindo, Assistant Director of Cottage Industry, Juai, wherein inter alia it has termed the construction of the MS building so and so was come under video within the estate is illegal and also recommended for shifting of the line. On perusal of the report and available document, it is found that MECL has not obtained. Now, what does it mean? This letter, my senior counsel is referring that they have withdrawn it. That is when they have withdrawn? After the filing of this petition. My petition was filed in 2018, and this letter was withdrawn in 2019.
You are referring to?
This letter of this referring to this affidavit respondent 2 and 3, that is page 12, annexure 2.
Just a moment. Annexure 2.
Annexure 2, page 12. This is the same letter which is withdrawn.
Yes, yes.
And this is connected to the letter which is part of my petition, page 23.
Okay.
Now, what is the content of the second paragraph? On perusal of the report and available documents.
Yes.
So that means they must have verified from the department that MECL has not obtained NOC permission from this department for construction of 33 kV and kV line passing through the industrial state. The joint inspection team is not the competent authority.
You're reading this.
Petition from writ petition amended. No, I'm reading. I'm reading this. Page 23. Annexure A8.
Very confusing. First, you're referring to the.
This letter. When they declared this is they have not obtained the NOC.
Now you're coming back to 23.
Page 23.
Yes. On perusal of the report.
On perusal, I'm just reading that. MECL has not obtained the NOC permission from this department for construction of so and so line passing through the Kletrichi industrial state. Second, joint inspection team is not the competent authority to declare any building or structure as illegal. In view of the facts report submitted by the team thereof, the team which is mentioned in the above, the inspector of electricity, is not acceptable. The MECL who has trespassed, Lordship, this is a very important word, trespass, into the land should shift the line to the safe place and providing right way and expenses required therefore for shifting of the line is sole responsibility of the MECL, being the service provider. It is maybe also noted that the service provider will be answerable for any untoward incident. Now, the same letter, Your Lordship, come to their affidavit. Affidavit on 2 and 3, annexure 2, page 12.
Yes.
In one hand, they are saying something else, and all of a sudden, after filing this case, they have come to this conclusion that they have sought for the cooperation. Look at the content. On re-examination, on what basis you have done the re-examination? Have you called all the parties?
Yes.
Of the earlier communication issued by letter dated so and so, 29/11/2017, which is a part and parcel of my writ petition. The letter dated 29 November 2017. That then MBCBA has sought cooperation of all concerned authorities, including the department prior to the construction so and so, which line was passed through the Kletrichi line industrial and the West Indian. Construction of the integrated line is meant for uninterrupted. Here saying that it will cause untoward incident and that respondable 4 and 5 will be solely responsible. Now saying that uninterrupted. Supply of power.
It says interrupted, not.
No, means they corrected. My Linux has corrected
Please
this.
corrected, not this.
Okay, anyway, whatever.
Anyway,
Supply of
we'll
power
look at
for larger interest of the public. At one point of time, there is a larger interest. Other point, they are saying that your entire process was illegal. So this is come in after the filing of this petition. Now, as far as that, my senior counsel has mentioned that I'll just go to this affidavit of 4 and 5, the page 13, annexure 5. Lordship, I'll go to first page 7, annexure 1.
Yes, sir. Yes.
Page 7, annexure 1. What is the letter? The written to the General Manager DIC by the Executive Engineer. What is the construction of 33 kV line from Ketechu village to Nartiang village? With reference to the subject cited above, I am pleased to inform you that the Meghalaya so-and-so soon start the construction of the 33 kV line from the Ketechu to Nartiang village. The aim of this project is to improve the maintenance of the stable power supply to the area. In this connection, the board needs your full support and cooperation so that the construction work, once taken up, not be interrupted or disturbed for the smooth and timely completion of this project. Your Lordship, all this argument, all the pleadings of all the parties, whether the petitioners or the other respondents, this is the only letter that the respondent of 4 and 5 they have in their position. In fact, in earlier order also, they are saying that whatever the documents you have since when you were incepted, that is the 20th April 2022. This order was passed there. Both the parties should bring their documents of the inception or their construction of their line. Whereas the petition already brought before the court, it showed sequence of events, how the land was allotted to me. This is the only letter they have, but there's no permission. Can they show any permission, any document before this court? Not at all. This is the only letter they have communication. They sought corporation. But whether the corporation is given or not, permission is given or not, that is already been admitted in the letter, this letter of the petition, that they have not obtained the permissions. Even use the term trespass. And all of a sudden, after filing this petition, they have come to this letter that, no, after the examination, we will doing these letters. So while we're doing the letters, you should have filed in a miscase. Let us be unheard on this matter. Let the court decide. You're not all of a sudden you had a dream and you just come and just do things. And that is written, the letter was 2017 and you were doing in 2019. So what is in between? What happened? What is the communication was done? Whether I have given the opportunity? And whether my land is illegal or not illegal, even if it's believed that it's illegal, why am I so allowed to run that business? And this license they're talking about, this is only the license. Yes, this department has given the license on the basis of the pursuance to the land is allotted to me. If my land, my entire structure is illegal, Your Lordship, do you think that they'll issue me the license, renew? I've been paying for it. I've been paying the rent for the land also. And they're all saying that I don't have the construction, I don't have the permission. Permission also I have shown, Your Lordship. This is the affidavit. This is the type copy. It's already countersigned by the DIC. What does it mean countersigned? That means something must have submitted, no? Had I been like just prepared from an engineer, government engineer, that is a different issue. But here the countersigned by the DIC. That means here that copy is on the thing. So once my blueprint, the plan, in this letter, in this that rules of electricity is saying what? If any stage, I'll just complete that.
Regulation 63.
Yeah, they've used a term plan. So this is my plan, Your Lordship, the type of it. It is countersigned by the DIC. Now they're saying that no, you don't have a permission. If at all my permission, if I don't have a permission, my entire structure is illegal. So why this in so many correspondents saying that the MECL doesn't have any permission? Now my entire unit is stopped because I don't have the workers, because nobody wants it. Because already in 2-3 communication, the state respondent is already mentioned that this causing the great danger because it is posing so close that if its big blow comes, Your Lordship might take the big mishap. So only this is my limited submission that whether I have the permissions or not, that is you can verify from this list of documents. And this land was allotted on pursuance to the thing. Now they are coming with the lease agreement. Lease agreement was executed in 2007, in 2012, in pursuance to the previous what other things are. So that means my construction started in 2007. And when the plan was submitted, and there's a point in the things after the signing of this within 1 month. So let's assume that I've signed this lease agreement 2007. So this my plan was countersigned by the 4th May 2007, and the lease agreement was executed on 24th April 2007. So that within a month. So this is the only limited I have done. This is all on the basis of these documents. There is communication.
So, I heard the parties Have you
Yes,
filed your
Lord.
written argument?
I'll have to, because I've
Have you?
not
We
yet.
have not, my lord. We
Not
will
yet.
file.
It'll be better because
Yes, yes.
there are
This-
so many
There's a lot of issues are there.
so many issues involved.
Yes.
You have
Yes,
to,
Lord.
it'll be better, if you prepare a table, a chart,
Yes, yes.
Yes,
I'll table the charts.
point wise, and reference to the
Yes, yes, everything.
the communications and letters.
For sure.
Matter has been heard, and the hearing is concluded. However, learned counsel for the parties have submitted that they may be allowed to file the written argument in this. The written argument, a brief synopsis of the argument in written form. As prayed for, this is matter to 2 weeks.
For 2 weeks. Actually, Lordship, I just have a limited prayer because my last year my mother expired. So this June, like she'll be completing. So I'll be going out for her all the rituals and all.
3
So
weeks.
maybe come after say the 2nd of July, Your Lordship, if you get kindly, because my entire families are there. After 2nd of July.
4 weeks.
Lordship.
Item number 5.
May I please, Your Lordship? Lordship, the order passed by this Honourable Court for the freezing the amount is in the Miss Case, Lordship. Miss Case number 83 of 2023, Lordship. And with this order, the Miss Case was disposed of accordingly, Lordship.
It's the order of 28th June, madam. 28th of June 2023 in the miss case.
Yes, miss. You were saying that after this order has been passed,
Lordship.
the petitioner had sort of violated the order,
Lordship.
in as much as they have refused to deposit the current dues.
Lordship.
Is that your stand?
No, Lordship, it is not with regard to the current dues because it is a little bit difficult to find out the current dues also. Though we have checked their dues, Lordship, it is like this, Lordship. Suppose in a month, Lordship, there may be 4-5 deposits also. So we are not sure whether it is current dues. After evaluating, we will know. Because suppose, Lordship, it is like this, Lordship. I'll just, if I make it much more easier, Lordship, it is like this. Suppose I have 20 employees. For 2 employees, I have deposited in the month of January. I don't know, means like the department till now, it is not aware unless and until proper audit is conducted that these 2 employees, the deposit for these 2 employees is for which month? Whether it is for past 1 year or whether it is for current month. That is not aware, we are not aware of. We only know that for 2 employees there is some deposits, or we also don't know for how many employees. It is the deposit will come around 304, 502, like this. So against the challan. So these 502 is for whom?
Yes.
That also we don't know. And these 502 or 300 something, or might be 82 rupees, we have seen small deposits of 50 rupees also comes. This 50 rupees is for which month and for which, because now it is all electronic. Previously there used to be a manual challan, so we used to know that against this challan for this month they are paying for this many employees. But now since all electronic, unless and until the year-end audit or something comes up, we will not know that for which month or for which date they are paying the dues.
So now
We only know that against this month, this dues is.
but your contention is that the petitioner, in violation of this order,
Is in violation of this order.
has refused or not deposit any amount.
Not deposit, not deposited. Yes.
What you see, if at all there has been a deposit against certain number of employees or for certain period of time, could be the preceding year or the current year, we don't know. They would be in a better position to have their records.
Lordship.
But as far as you're concerned, you don't know, because it just appears in the
The numbers, it appears in the numbers that yes, after defreezing there are some deposits, but we are not sure that for which month or for whose deposits are there. We are not sure. There are couple of deposits in the month of July itself. There are couple of 4-5 deposits, but we are not sure for which month or for which. It is not disclosed.
So what is your grievance now in that regard?
Lordship, Lordship, it is the Act itself is very clear that if they are not satisfied with section order passed under section 14 14B and 7Q, then their appeal lies. So
that is one aspect of the matter.
yes, Lordship, and also Lordship, as per my para, Lordship, the date might be corrected because it is not 2106, it is 2806. After depositing the account, after defreezing the account,
You are referring to?
my written argument para 15. My written argument para 15.
No, you go to the.
The only contention it is.
Yes.
That after the date may be corrected because it is 2106. I may be allowed to correct the date. It should be 28 because the little bit confusion was there.
Yes,
It should be 2806. There is a the penalty was
Para 15.
para 15.
Oh. It should be 21/6
It should be 2806.
instead of this 21/6 2023.
2806.
No, just so. This is defreezing of the account.
Right,
Yes.
order dated 28th.
2806.
Okay, instead of 21, it should be 28.
28. So Lordship here also is saying is that interest is separate thing, damage is separate thing. So the interest part which we have already made a table in para 12 also, that what is damage, what is interest. So either they should take some initiative when the correspondence was, when there was an open talk, when the court also tried for two parties meet together and go for an amicable settlement. There was no cooperation from their side. It is admitted that there is a delay. After 15th of each month, if they pay, then there is a delay in the payment. So obviously damage and interest is attracted. If we take loan for some purpose and we skip the loan dates, by somehow our loan is 5th of every month, somehow we miss the loan date, then after each day there is a interest added on. The same thing also happens here. After each day they misses, there is a interest day which we have mentioned, that up to 2 months, up to what up to less than 2 months worth, more than 2 months worth. These are the slabs. So each day they are missing, they are liable to pay the interest. Interest part also they have not come up. Either if they say that okay, we are ready to pay interest, for damage we want to file before the court, That is also separate thing. The corporation should be there. If they have violated, the clear fact is that they have violated. So on these grounds only I have placed that they are not cooperating.
So, Mr. Dev will shut down your school.
Lordship, I didn't really understand the
I see.
apprehension.
Plain and simple fact is this: that you are supposed, it's incumbent upon you to cater to the requirement of your employees.
Absolutely.
More particularly, you see, these are social
Yes,
welfare
yes, yes.
legislation,
Yes.
and if we don't say bias, also the balance will always tip towards the welfare of the employees.
Absolutely. Absolutely.
So, if you have done so, you should clearly state that you have done so. If you have defaulted, then what is the the correctional process that you have pursued?
Yes.
You have not done that,
Yes.
and in spite of the concession given to you by defreezing of the account,
Yes.
as has been submitted, you have violated that trust.
If I may just make a few submissions, my lord. I don't want to re-argue the entire matter because now it has already reached this stage. Lordship has seen that the order which was passed for recovery was pertaining to the period from 1996 to 2008, and a certain amount was reflected therein. Against that, my lord, we came up with this petition saying that the amounts have not been explained to us, and so you should send some notice and all. They were left unanswered. So on that ground we came. In the first few rounds of hearing, my lord, instead of pressing for the matter on merits and demerits, we tried to settle the matter amongst the parties, and however, for some reason or the other, my lord, the settlement could not have been arrived at. At that point of time, my lord, by your lordship's order of June 2023, lordship had directed that my bank account should be removed from any encumbrance, and I should be making the running payments, and if they have any complaint, they can come and pray for freezing of the account. This was passed in June. Now we're in May of the next year, my lord. No such prayer has been made, and I have made it, since my friend is referring to her written argument, I have also stated in my written argument that pursuant to the order and during the pendency of the matter, we have been paying running deposits. Now, if they cannot ascertain whether it is running payment or to a present, that because we are paying it, my lord.
But do you have the records with you?
If required, we can produce it. We can
That
produce
is much
it.
better.
If required, we can
So a
produce
clear
it.
picture will be, will emerge.
Now,
Because that would be, you see, that would be your stand as far as your bona fide is concerned.
yes, absolutely, Lord.
That,
No,
yes.
it appears from my submission of my learned friend that we have been making payments, but they are not able to ascertain whether they are running payments or past payments.
Because you see, from what I could understand,
Yes.
if there are some payment of 500, some of 50
Yes, yes.
rupees, and some of 300, then it will be confusing.
I
Rather, it
understand,
should
I
be
understand,
explained.
No, I believe the school also will have the relevant
They will have
records.
the
If required, we can put a chart or some
think that will be much
form. But otherwise, this issue.
Can you do that?
Yes, I'll do that, Lord.
So that aspect of the matter will be clear as far as the freezing and defreezing.
Yes,
of the
as far as my conduct is concerned, I don't want to leave
Conduct,
any aspersion, Lord.
So I think we are left only on that issue.
Yes, and otherwise the issue.
As far as the merits are concerned,
Yes, those are there, my
that
lord.
is
My
already
contention is that it is to be 25%, their contention is to be 37%. That's simple.
So how soon can you do that?
Should kindly grant me 2 weeks' time. I may kindly have it next week. In the meantime, I'll try to ascertain what
Lordship,
exactly
it
is
is available online also, Lordship. It is just.
I think they can also.
But it is that is what I am saying.
To be
The
very
only
honest, I
thing
also don't know the technicality right
it is
now. I have
available
to-
online. It can be seen through online. But that is what I am saying. We have checked. It is coming as 300 or
Okay, that is okay.
I'll try to.
He will
I'll
have the
try
recording.
to.
It's against whom or against
Which
how many
period,
employees or
yes.
yes.
that is what we want to know. And how many can you just see at the in your chart?
Yes.
You give the number of employees.
Lordship, yes.
Would it be 20 plus?
Lordship,
Or
it has to be
exactly?
20 plus because
It has to be
otherwise,
20
yes,
plus.
yes.
But how many?
I'll try to do. Kindly give me a week's time, Lordship.
The matter came up for hearing. Mr. Njishila, learned counsel for the respondent 4, has referred to this court's order dated 10/5/2024 and has submitted that
Last order.
Unum to? And has submitted that this court, by order dated 28/6/2023 in Miss case number 83 of 2023, upon hearing the parties have passed the order effectively allowing for the account of the is it a saving account?
So, nature of the account.
Should be saving or current? Just to details of the account.
It's the current account number 108812482659 at SBI Rinja branch.
What is current account of the petitioner being number? Can you give Mr. Dev?
Lordship, it's at page 22 of my writ petition.
Just
Account number 1088
1088
1248
1248
659
659.
at State Bank of India Rinja branch.
At the State Bank of India, Rinja branch. The said order is still in force till date. In course of hearing, another issue has cropped up, that is in respect of the deposit made by the petitioner towards the dues of the employees as far as the EPF is concerned, where there is no exact information as to the amount deposited vis-a-vis the employees or the number of employees of the petitioner school. Mr. S. Deb, learned counsel for the petitioner, has then submitted that he may be allowed to assist this court by filing a proper chart in this regard, indicating all the relevant information sought for. Anything else? This being the case, this matter will now come up after 2 weeks. Otherwise, you have filed your written argument.
Yes.
Both sides. Of course, you have not. Of course, I think your role is over. So 2 weeks, sir?
Much obliged.
Second call, item number 2.
Yes.
See, from my side, I have argued only 10 minutes. I need to argue. After that, that KP, that State Council might take little more time. In fact, the matter has heard substantially. And after that, court asked the state
Now
respondent.
we are only on that issue of the tribunal.
Tribunal, so far as the
As far
tribunal.
as the RTI.
Yes, there is no, yes. Now in the supplementary affidavit, what he has pleaded that although there is no tribunal, but there is some other mechanism. Although I have availed that mechanism, because I have filed a representation before the district authorities, but did not put up before the directorate. So he says that that is why my writ petition was premature. But so far as the statutory provision with regard to the constitutional tribunal is concerned, he has considered there is no tribunal.
There is no tribunal, but provision is there in the Act.
There is no provision. Yeah. For constitutional tribunal, there is a provision, Lordship. Rule 20, Lordship.
20.
Rule 20. Now he has relied some provisions of RTE Act as well as the rules. So I'll just read out that provisions. What does it say? Some section 18, section 19, section 20, again rule 20, rule 13 of the RTE rules. I'll just read out and I'll conclude my. And I'll rely on judgment even if there is alternative remedy. Although there is no provision for, although they have not constituted a tribunal, even if had they constituted the tribunal, still there are 3 circumstances. Alternative remedy shall not be a bar.
That is so.
Yes.
That is well settled.
Yes, if the order is passed without jurisdiction, if the order is passed in violation of principle of natural justice, or if the virus of the act is challenged, so that alternate remedy will not come into play. Now, Lordship, because he applied for leave today and tomorrow, that Mr. Bhattacharjee, KP Bhattacharjee. So can I day after tomorrow? Day after tomorrow he will be available, I think, because he is today and his leave is reflected today and tomorrow.
21st. Biar aku cari kebun.
Today is 21st, no? Day after tomorrow, yes, 23rd. If it is not 23rd, then Lordship, 23rd.
Mr. Associate Learner Counsel for the petitioner has submitted that he may be allowed to advance the concluding part of his argument as far as this matter is concerned. However, in the absence of the learned GA appearing for the state respondent, it is prayed that this matter may be adjourned for the day and to be heard on the next date fixed. Accordingly, as prayed for, matter is adjourned. This is the same on 23rd May for further hearing.
Oblige.